Hello everyone and welcome to today's Mondac webinar in association with R&P China lawyers, who will discuss how to be compliant with the extensive data privacy legal framework in China. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Martin Roos has over 20 years of experience in the Chinese legal industry, and his firm R&P is one of China's primary boutiques for international companies. Asia Law leading lawyers, chambers and Legal 500 have recognized Martin as a preeminent practitioner in China. He supports them on corporate and commercial projects, regulatory compliance and data privacy, and employment law. Connie Chen focuses on privacy and data protection, cybersecurity and regulatory matters, and she mainly supports international clients on data security inspections and assessments, establishing data compliance systems, filings with the Cybersecurity Administration, and dealing with government inspections. And finally, Alice Peng. Alice joined R&P as a partner in 2020. Alice supports multinationals on internal and external compliance investigations and represents them in administrative and criminal enforcement actions. She also helps her clients to build effective compliance systems and provides trainings on compliance, dealing with government authorities and dispute resolution in China. Now, before I hand you over to our panel to begin today's webinar, a quick housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. And we do encourage you to please submit your questions to the panel. We will endeavour to answer as many questions as possible during our Q&A session, but please do reach out for any additional information you may require. It's now my pleasure to hand you over to Martin, Connie and Alice to begin. Thank you.
Thank you very much, Dan. Good evening, good day, good morning to everybody. I'm aware that there's people from all over the world joining this seminar or this webinar. That's great because it's a very important topic for a lot of different companies. Looking at the contents page, what we want to do, sorry, next slide. Ooh, that's going a little bit slow. Very briefly on the content page, brief intro of us we've already had, so we can skip that. I will be discussing a little bit an introduction to the PIPL. Also, I will be talking about who is going to be affected, or is affected by the PIPL. Then my colleague is going to go a little bit more in depth on the obligations of a data handler and looking at the legal consequences of incompliance, while my colleague Alice will focus on data privacy enforcement. So really, what does it mean and what do you need to watch out for? And I will conclude with a bit of advice. Next slide. Dan? So, an introduction, and we can skip this slide, Dan. So the PIPL stands for the Personal Information Protection Law. There's been a lot about this. It was adopted actually already almost 2 years ago, but we're still working on it. It forms a backbone of China's data regulatory framework together with the PRC data security law and a PRC cybersecurity law. What is most important to understand that the PIPL was really the start. Over the past 2 years, numerous regulations, rules, standards, all kinds of implementation measures have been adopted. And in fact, on a monthly basis, we are issuing a newsletter with new items to be said about this. At the same time, it is now, after 2 years, unfortunately, quite clear what are the obligations of companies that are dealing with personal information in China. And in particular, and that's a key focus for multinationals, the companies that we're supporting, and what do they have to do to ensure that any cross-border data transfer is being done in a compliant way. Next. So briefly on some key definitions. So the first point here is we're talking about personal information, also referred to as personal data. In this presentation, we work with both concepts. So that's information of people, right? Information that relates to identified or identifiable natural persons. So we're not talking about company information. I get that question a lot. Yes, we've got a database with clients, companies that we're working with, we don't worry about that, but we are worried about information of natural persons. If it's anonymized, then that's fine. If it's pseudonymous, Jesus, very difficult word. The word that's on your page. Then it is still falls under the PIPL, and you'll have to deal with the PIPL. One very important distinction the Chinese law makes between personal information and sensitive personal information. I know that the GDPR does that as well, but the categories under Chinese law are quite different. And in particular, there's this whole stricter category, right? Sensitive personal information needs to be dealt with in a more sensitive way, and it's a very broad category. It includes, for example, ID card information, bank account information, but also all personal information of minors. So think if you have an employee and you know the names of the children, then that would be regarded sensitive personal information and requires extra attention. Second definition is regarding the PI handler. So this is the party that independently determines what is being done with the personal information. You have similar concepts under GDPR, but they're a little bit different. And so we focus on our definitions, right? And the key contrast is with the entrusted party. So the information handler is, for example, the company that collects personal information and does something with that, for example, transfers it to headquarters. And then there's the entrusted party, let's say a cloud service provider, which does handle the information, but not directly, only as an entrusted party. A final point to make here is that it is irrelevant how much personal information is handled. So PIPL applies even if one piece of personal information is being collected or transferred or otherwise processed. That's an extremely important distinction, because a lot of our clients deal with quite limited amounts of personal information. And so for them to take all these additional steps to ensure compliance seems like a big ask. On the other hand, that's how the Chinese law is drafted. And so that's something that we will just have to deal with. Even if the amount of information is limited, it still falls under the PIPL. Dan? Second part, territorial jurisdiction. So who is then subject to the PIPL? Dan? Or Aaron? In this slide, you can see, well, you can have a look at it while I talk. For us, we distinguish two scenarios. The first scenario A is a company that is in mainland China and is processing personal information of individuals in mainland China. So processing means collecting, it means aggregating, it means transferring, potentially it means analyzing, and hopefully it also means deletion. So that's clearly an area that the PIPL covers. At the same time, we also have a second area. We have companies that are not in China at all, but are dealing with personal information of individuals who are in China. So we're not talking necessarily about Chinese individuals. So if you're living in Portland and you have Chinese friends, don't worry about that part. But if the individual or the data subject is in China, including myself as a Dutchman, 24 years in China, my information is subject to PIPL if you as a foreign company are processing that. There is a but, because otherwise it becomes very, very broad. It needs to be for a certain purpose, one of two purposes. One, the foreign company needs to be processing this personal information from a Chinese natural person or a natural person in China, either to provide products or services to those natural persons in mainland China, so a very commercial objective, or the objective has to be to analyze or assess the behaviors of natural persons in mainland China. So it's not only about sale, it's also about other commercial purposes. Dan? Next slide. I want to give some examples very specifically to make sure that you get this point. So scenario A, a company in China. Now, the most obvious example is a Chinese subsidiary of a multinational company, right? A company that is in China is undoubtedly dealing with personal information if only employment information, information of its own employees, though of course many multinationals also deal with other information. Think, for example, a retailer who's collecting information of its customers. That's definitely covered. A second kind of office, a representative office, doesn't mean a subsidiary, but it means some kind of presence. And as soon as a foreign company has any kind of presence in China, the data processing is regarded as commercial, and so the PIPL applies. Now, what is a little bit more tricky is if the company is abroad and dealing with or handling personal information from individuals in China. I have 3 examples here. The first is a US e-commerce platform that has a Chinese language option on its website, and payment can be made through Alipay, one of the big Chinese payment portals. Obviously here, the focus is on selling something to Chinese consumers. And so remember that first definition, so to provide products or services to individuals, natural persons in China, that is covered. So if you are a US e-commerce platform that is selling into China, then the PIPL is something that you need to consider. Second example here, a French market survey company entrusted by a French wine chateau to conduct surveys on Chinese consumer wine drinking habits. Now, I can already tell you a lot about Chinese wine drinking habits, including of last night, but for the purpose of this presentation, this is definitely covered, right? A French company, or wherever the company is, if it is collecting private information, personal information from Chinese natural persons for analyzing or assessing, well, certain commercial behaviors or personal behaviors, then that falls under the PIPL. A third example, and you may guess that's one that does not fall under the PIPL, is say you have a famous Chinese food restaurant in Peru that uses websites for online reservations. So if I decide to go to Peru in 2 months' time, I'm going to make a reservation now. I'm going to add my personal details. Do we expect that restaurant to consider the PIPL? And the answer is no, because they're not targeting people like myself. They don't have a Chinese language option. They don't have, as with the first one, Chinese payment options. There, the burden isn't as high, and this restaurant can continue doing its business without worrying about application of a law on the other side of the world. I hand over to my colleague, Connie.
Thank you, Martin. Okay, hello, everybody. And for my part, I'm going to talk about the obligation of the personal information handler. Actually, PIPL impose numerous obligations to the PI handler for their data processing activity. But in this part, I will only focus on 2 activities: personal information collection and personal information transfer, because these are very closely related to the data cross-border transfer. I think that is the most the topic that you may have quite a lot of concerns about. Okay, first let's look at the personal information collection. Yes. PIPL actually set forth 7 legal grounds for the personal information collection, but I'm not going to go through all those legal bases. I will focus on the informed consent and the human resources management. For the informed consent, undoubtedly, it is the most frequent used legal grounds for data collection. The law requires that a data handler should inform the data subjects regarding like what kind of data I will collect and who I will to whom I will transfer the data, and how do I process your personal data, and etc. This is the notification. In terms of the consent, I think there's quite unique in PIPL because there's 2 types of consent: general consent, or you may call it blanket consent, versus separate consent. Separate consent generally applicable to several scenarios, such as if you are collecting sensitive personal data, or you are transferring the data to out of China, or you are transferring the data to a third-party personal information handler, then you need to gain a separate consent from the data subject. Okay, next I will go to the HR management. Sorry, then the previous slides. Then go back to the previous slide. Yeah, the HR management. It is also a legitimate ground for processing your employee data, right? The point here I would like to point out is that there's quite a lot of ambiguities regarding scope of HR data. So in practice, we generally recommend our client to also trying to collect the consent from the employee for processing their personal data, in particularly in a very sensitive scenario like transferring the employee's data to their headquarters. To avoid this is the cautious approach to avoid the arguments, and also to enhance the legal certainty. But I think in maybe in the near future, there would be some official guidance or cases to like have some detailed interpretation on regarding the scope of the HR management. And for other legal grounds, I'm not gonna go through all of them. In addition to the legal grounds, you may also, the PIPL also requires that the personal information handler should justify the necessity of processing personal information, and also to minimize the scope of data to be collected. Yes, next slide. Okay, next I'm going to talk about the personal information transfer. Say if you have a subsidiary in China, and you are collecting the information from natural person, then share the data with a third party in China. What you need to do is basically two key things. The first thing, you have to obtain a proper consent from the natural person, right? Please note that if you are going to share the data with a personal information handler, then you need to seek a separate consent from the individuals. For example, if you are a travel agent and collecting the customers' information, then share with a hotel. The travel agent and the hotel will be considered as a co-handler of personal information. In that case, you have to gain a separate consent from the data subject for processing the data. And the second part is the contract. You gotta have a proper contract in place to specify the scope purpose of the data processing, and also set forth some onboard transfer restriction on this on the contract. Next slide. So you may ask, what if the third party is located out of China? Then it will be considered a data outbound activity and subject to more restrictions under PIPL. The third thing, for sure, you need to gain a consent. But in this case, because it's relevant to a cross-border transfer, so you need a separate consent from the data subject. And the second, contracts. In this case, you will need a data cross-border transfer agreement in addition to your business contract. And the third restriction is that you got to go through all the government proceedings. If you are processing large quantity of data, you got to pass the government security assessment. If you are doing like a small scale, a very small scale data, then you have to go through the standard contract filing or you have to apply for a certification. In reality, the certification is not being used quite frequently at this stage because the legal the rules regarding certification is not quite clear at this point. So most of our clients who are small scale data exporter are choosing standard contract filing to export their data. On the next slide, I want to introduce in depth. Next slide, Stan. I want to introduce the differences between the security assessment and the standard contract filing. As you can see in this slide, the trigger is quite different. If you are dealing with massive personal information, you can see the number here, then you are triggering a state level cyberspace authority of China's security assessment. Then if you are dealing very small amount of personal information, for example, if your Chinese subsidiary only have like 5 employees and only transfer 5 employees information abroad, then you can go through the standard contract filing process. The filing is made with the prevention level CAC. The process is much easier comparing to the security assessment because in the security assessment process, it's very complicated. It is very time and cost consuming. For the document to be submitted to the government, looks like similar. You need a privacy impact assessment report plus a data cross-border transfer contracts. But according to the guideline issued by the CAC, the PIA report, the content requirement on the PIA report is quite different from the security assessment and the standard contract filing. In terms of the deadline, sorry, there's a typo here. The security assessment deadline should be 20 February 2023. The deadline has already been passed, but per our practice, the CAC is still accepting the filing. So we will recommend the large-scale data processor to file the security assessment as soon as possible to avoid the legal risk of being published by the government. For the standard contract filing, the deadline is November 30, 2023. This year, we still got like several months to complete the filing. We also recommend those, small scale data processor to conduct the standard contract filing as soon as possible. Next slide. So you may ask, what's the legal consequences if I'm not filing those, making those filing or apply for the approval? Let's look at the consequences. Next. So for the company, if you're serious violated the PIPL, then you are gonna face the suspension of business or like up to 5% of previous year's turnover. For those foreign companies, your website could be blacklisted by the local authority, or you are prohibiting from transfer the personal data abroad. And also there's personal liability. This is very unique in China, totally different from GDPR. Like in the company's DPO, data protection officers, or the CEO might be face personal penalty up to CNY 1 million if the company breaches the PIPL. Also, if the company is being sued by the data subject, there could be some civil liabilities. and also there's criminal liability. We've already seen people being convicted and imprisoned because of violating PIPL. Okay, I'm gonna transfer to Alice for sharing the enforcement trends in China.
Hello, everybody. Yeah, my legal practice is mainly focused on the compliance and the law enforcement for the past nearly 20 years. So take this chance, I want to briefly give you an overview of the enforcement trends. Next slide, please. Yeah, so data privacy law is still quite new in China, and many companies, especially those not handling large amounts of personal information, believe that they are unlikely to become a target of enforcement actions anytime soon. They may be right. However, let's look at a number of the key trends. First of all, you see China, we all know that it's kind of a campaign style enforcement, right? And for example, for currently, anti-bribery for the pharma industry becomes a hot topic currently. But we can see that maybe next hot topic could be the law enforcement target on the PIPL enforcement. More generally speaking, we see increased supervision, more investigations, higher fines, and more individuals being targets. So I have to say, in the beginning, maybe mainly companies think they are the targets, but we see a lot of cases for more focus on the individuals, not only the high senior leaders in the companies, but normal staff. So this is a trend for everybody need to be noted. And also, a lot of the efforts as companies is going to filing requirements, which have now been clarified, and mandatory internal audits on PI processing activities. Or in other words, as long as companies ensure that they complete filing requirements and mandatory internal audits, they should be reasonable, fine, and safe. At the same time, for every company, a key risk seems to be that a government audit triggers as a result of a whistleblower. Personally, I see a lot of more and more whistleblower cases from like employees, because please understand that in China now, more and more employees maybe could be the whistleblowers for the company risk. And with so much work to do, the CSA is going to be understaffed, but it will want to get some easy wins. This means that any company could become a target. And so the key is to get one's house in order. Next page, please. We give everybody some example of recent administrative cases. You can read the cases here and we will take questions from you. You will note that the targeting of the internet companies and F&B establishment in Shanghai, and also the escalation into fines on individuals in the case of the Nanchang University. I just like to give a tip here, say, for example, companies outside China, I think you need a reliable contact in China who is close enough to the law enforcement practice. And so therefore they are able to alert you any required must actions in China, so you can take immediately. Also, you need to at least take some basic steps, requirements according to the law, like what my colleagues have already mentioned, like a consent letter to collect customer information, and also maybe have some data protection SOP internally in the company, etc. So at least when anybody knock at your door, you can show to the law enforcement authorities you are in good faith. You are in good faith in compliance with the law. So that can really help you with the law enforcement. Okay, we hand over to my colleagues. Thank you.
We work fast. I hope that that's appreciated by everybody. It will give us also more time for questions. I do have a bit of a conclusion here, and I'll try to summarize a little bit as well. Next. So in the end, when it comes to data privacy in China, it's a huge topic, right? There's still a lot of things developing. There's new rules, new implementations coming. But fortunately, after 2 years of talking about it, it is now pretty clear what has to happen. Now, of course, what that means to you depends on who you are. What kind of company? What do you do? Right? We set some examples here today already. The difference between a security assessment and a standard contract filing, for example. We work, for example, with a number of airlines who are dealing with huge amounts of personal information. Of course, they have to go through this very complex data security assessment process, but many others, they just have to deal with a more simple approach, which is still much of a headache because it takes time and it takes effort and it takes costs. What does that bring us to? A couple of a bit of advice for the international companies that we deal with on a day-to-day basis. We're splitting it in two. First is companies with offices in China. I think one message that is already loud and clear, and that is probably not only in China but also in other jurisdictions, is data localization as much as you can. That doesn't mean all, because that is unlikely to be possible, but we see a lot of clients who come to us and say, yes, for example, we have got an ERP system, which means that our individual customers, all their data is going into an ERP system which can be accessed from Germany and Singapore. Yeah, that doesn't work. Well, it might work. If it's necessary, it's necessary. Then you have to go through the consents, through the you have to go through all the processes to make this all compliant. But if you don't need it, if it's just an ERP system because you like to have an ERP system and it's convenient to have it all on one server somewhere in Germany, then our advice generally is maybe you should be thinking twice, because data localization is a trend. Keeping it as much as possible, this personal information local, just sets so much less of a requirement on you as a company to deal with this information. So that's one. The second is regarding filing requirements. I think both my colleagues Connie and Alice raised this. So there are filing requirements. If you are a company in China, you're going to have to fulfill it. There's also annual requirements, again, depending partially on the volumes, but you'll have to do an audit every 2 years. That's something very, very new. But these are steps that you will have to do. One question that I get a lot of clients is, do I have to do it now? And I have to be honest, right? The world will not crash. The sky will not fall in if you do not complete it before the deadline of 30th November. However, there is an increased risk. At some point, you could be caught in some kind of scheme, whether it's because you're in a sensitive industry, whether you have an employee who's unhappy, whether you have a government official who doesn't like you. And if you do get an investigation or an audit from the government authorities and you do not have your house in order, then think of all the trouble that you're getting on, right? As opposed to, if your setup is relatively simple, then it's also not so very complicated to complete the filing requirements, sign the contracts that you need to, get the consent that you need to, and get it over with for the next 2 years. So I think our advice generally is, if it's simple, get it over with as quickly as possible. If it's complicated, then you've got more to lose and you should be getting it over as quickly as possible as well. A final point for companies with offices in China is what we are seeing is that Chinese individuals are becoming more assertive with their personal information. I will tell you, I've been here for so long. I've been here for more than 2 decades. 20 years ago, if somebody stole your information and sold it online, nobody would be surprised. Nobody wouldn't even say anything. It's completely normal. If I went to a real estate agent to rent a house, I would always give a fake number. You never give your right number because you know that you'll be getting a dozen calls a day from somebody who has purchased your information. But Chinese society is sick of it, as European Western society, as people in Singapore and Australia. Personal information and the protection of that, and next to the right of privacy, this is something that is here and that is here to stay, and that is just as strong in China as elsewhere. Certainly in first-tier cities like Shanghai and Beijing. And that also means that if you, as a company in China, get questions you need to know how to respond to that. You cannot say to an employee, yeah, well, I'm not sure. Or let's say that you have a candidate for a position, and during the interview, and I've had it only 3 days ago, the candidate asked me, so I've provided you with my personal information. What process do you have to delete this information if I do not get a job? And to be frank, because as good lawyers, we advise well, we don't always do it well. I didn't have an answer, but I'll tell you, I have an answer now, right? So you have to, in China, deal with these things in a proper way. That's part of you as your responsibility as a good citizen, but it also will save you a lot of difficulties longer term. Now, when it comes to companies that do not have an office in China, but deal with personal information from China, I think there's a couple of pointers here as well. One is separate consent mechanisms for users from China. So if you are communicating, for example, through a website or through an app, you should make sure that the requests for consent are compliant with PIPL. We still see far too often that companies think, yes, but I am GDPR compliant, and so it doesn't matter. And unfortunately, GDPR and PIPL are two different things. And although there is a lot of overlapping, so you do not have to do everything again, it is necessary to do a little bit extra to ensure that you are compliant with Chinese law as well. Data outbound compliance is just as important. When you're receiving that information, you need to make sure that it's coming through the right channels, right? And that you're doing something with that is appropriate and that is permitted. And then perhaps the most difficult is that under Chinese law, if you are collecting information that is subject to, so personal information, PI, that is subject to the PIPL, then you should be appointing somebody in China for handling PI matters, basically to receive complaints, questions, but usually complaints from data subjects who are providing you with their information, because the Chinese system thinks if they have to go all the way to, let's say something, they have to go all the way to the UK to get their right. That is not convenient. And so somebody should be appointed in China to handle these complaints and have a level of responsibility, perhaps even liability to dealing with private information issues. Now, this is one area that is still completely unclear what to do with it. We do already see some agents who say, yes, I will be your representative, but what that means, what kind of liabilities they have, how should the data processor abroad control this person, that is not clear, and we look forward to implementing rules on that topic. But it is for companies, especially companies that deal with large amounts of data from China, it is also something to very much keep in mind. And that's linked to that, and what Alice just concluded on is things are still happening, and so you have to continue to be updated about what is developing and how it will affect you as a company. For my final slide, we've got a little bit of an action plan here. It's not too elaborate because every action plan depends on what a company is, what a company does. I think the first thing, and the reason why we put it first is because this is often what is the most worrisome for a lot of international companies, is fulfilling requirement for data outbound, for export of personal information, right? So if you are a company here in China that is exporting personal information, then these 3 points are what you should be thinking of. Data processing management of third parties, right? Transferring personal information to third parties, export clearly, but also within China, or companies that are outside China and are transferring it to third parties outside China. These are all areas that you need to be considering, mainly as a part of contract management, but in some cases also becoming a co-processor, which means that that party needs to also make sure that they have consent from their Chinese data subjects or data subjects in China to ensure that things go right. Within China, collecting from a vendor supplier, I'll give you a very specific example. A client of ours is a B2B operator, so they're receiving information only from vendors, from suppliers who are sharing business information, but that includes personal information as well. So in the end, our client is receiving personal information from business parties. And because this is going all into their elaborate ERP system, which is also accessible abroad and on the server in this case, Poland, therefore the PIPL very much applies. Now, the question then becomes, does our client as a B2B operator need to get consent from the individuals whose personal information is being transferred to them? The answer to that is no, right? Because the individuals are not their direct counterparty. However, the contracts with the companies that are providing this information, that is a completely different matter, because in effect, it is one company who is receiving the information and then transferring it to us, and then our client is transferring this on. And so our client is a co-processor and needs to make sure that consents are in place, or that at least somebody is taking care of ensuring that the private information is protected in that chain. A third point here, internal policy, SOP development, that is very much linked to what I was just talking about, right? You need to have your policies on how to deal with that. Now, to be honest, this is a work in progress for anybody. I spoke to a Belgian client a couple of months ago when I was in Belgium, and we were talking about data privacy in China and about GDPR there. And basically, they said, yes, we're covered. In China, we're covered. Well, okay, that's great. I'm always happy to hear it. And in Belgium, we're also covered. But, you know, that doesn't mean we're covered with everything, because he mentioned as a very specific example. I'm sure that he said, I have in my email box information of candidates of 10 years ago, right? Because I don't delete information directly and then it's in my inbox and I leave it there, etc., etc. And of course, this is not compliant with GDPR, but so what? And he's right, so what, right? On the other hand, what China is asking is that you at least have the procedures to have a process to deal with these things. And whether it always goes right or whether occasionally something goes wrong is a different matter. But what we really need to be doing is establishing these processes so that in the whole chain of events of dealing with personal information, that personal information is protected as well as possible. The final point is regarding outward facing channels. If you're selling, so if you're a foreign company, but also if you're a company in China, let's say in the retail sector, and you're selling online, you're selling through apps, then you have to make sure that your disclaimers and your protection clauses in there are again also PIPL compliant, right? There's a new law or a new regulation that came out for app compliance. So of course, personal information in apps needs to be protected. It wasn't entirely clear how that worked. Now that is very, very clear. And this is a constant process as well. But in the end, the goal is always the same. Try to have privacy policies, cookie policies, ICP filing requirements covered so that you are compliant with the law and you do not risk that somewhere, sometime, somebody is knocking on your door and saying, hey, there's something wrong here. We're going to audit you. We're going to come in with our gang of government officers. We're going through everything that you've done. And for the next day, week, month, year, we're going to make your life miserable. Try to avoid that by being as compliant as possible. Thank you very much. I believe that we can take questions now. Dan, I think that you're going to play a role in covering this.
That's right. And before we move on to the Q&A, I just want to say thank you, Martin, Alice and Connie, for your really interesting discussion and presentations today. Really fascinating topic, and we've had a great audience with us today who've sent in plenty of questions, and I'm sure they're thrilled to have been here with us today. So I'll move straight into the Q&A. We have about 15 minutes. We have a few questions in, but plenty of time if you do want to send in a question. And we'll start with this one. Does processing personal data for purely employment or HR purposes, not require express consent of the individual, even if we are transferring that employee's personal data to a third party, for example, to a vendor to run a survey. If you want to read that question to our panel, you should be able to see that in the toolbar if you want to have a look at that question. But I'll let you decide who wants to take that question on.
Yeah, I'll take that one. So you do need express consent. So one of the legal grounds that permits you for handling personal information is HR management. The problem with HR management is that is a fairly broad concept, and we can argue whether something is necessary for HR management or not, right? We can argue about that all day. We can spend a week or a month talking about it. So on the one hand, you do not want to have that risk. So what in implementing rules and in practice, what you sometimes see is that people say, well, as long as you have your employment handbook, which creates a clear policy, we need it for this, then it's okay. You do not need separate consent. On the other hand, I would always say try to avoid that, especially if you have only a fairly small team, right? If you have 1,000 employees, then having a broader consent is based on HR management is great. If you have 20, I would always get individual consent for data processing. That's one. But second is when it comes to specific consent for transfer to a vendor, if it's a vendor, an agent dealing with payroll, fine. If it's going to HQ, for example, well, you can all say that falls under the HR management concept. But why does a company have to send information to headquarters if the company has an independent P&L, right? So subsidiary in China has a payroll provider, has a general manager, but HQ wants to send that information. Are you sure that you can argue that it is necessary for HR management purposes? So there also very much specific consent is a much better idea. Also, because if it comes to export of this personal information, we will need to include it in the PIA that we're going to file with the government. And so if we file in the government the PIA in which we say we don't bother with consent because we're doing HR management, we're basically asking for trouble. So if it is somewhat feasible, we would always recommend go for that consent. We work with beautiful temps. It's very simple. We have a standard policy. We have consent forms for information, for sensitive information, for data export. We detail where it's going. You cannot go wrong with that. It's such an easy process. So to conclude, and thank you very much for this very good question. HR management, if you have nothing in place, you can always argue it, right? And you might have some level of defense. We would not recommend that you rely on that unless you absolutely have to.
Brilliant. Thank you, Martin. We have quite a specific example in this question. So in the example of Nanjing University data breach, the university was fined. Were the hackers caught and fined too?
Question?
Repeat the question again, Dan. The Nanjing University cases?
Yes. In the Nanjing University data breach, the university was fined. Were the hackers caught and were they fined as well?
Well, I think the hacker should be subject to the cybersecurity law instead of the personal information protection law. And also the authority governing this issue should be different government authority. The hacker is under the supervision of a public security bureau instead of the cyberspace security authority. So for sure, both the university, who is the personal data handler, and also the hacker will facing the penalty from the government, but from the different agencies.
Brilliant. Thank you very much, Connie. We have quite a long question here. So if you are able to sort of read along with this question as I read it out for the audience. If the individual is an investor to a fund and a fund is managed by a manager, then a fund is invested into B fund managed by B manager. If B managers need to transfer such individuals' personal information provided by A manager overseas due to the contractual obligation, and because B manager has not direct legal relationship with the individual, B manager cannot obtain the consent letter from the individual directly. So how may B manager solve that dilemma?
I think Martin just like explained the similar cases.
I think this is really similar to the example I provided, but it's lots of A's and B's here. But if you are a business, let's put it more general, right? If you are a business and you're receiving personal information from another business and you're exporting that, you cannot be expected to go to your business partners, individuals, and get their consent, right? You cannot skip over your business partner and go to individuals because then you'll be doing that for a long time. And if they don't, I mean, your relationship is not with them. So from a contractual perspective, what I would want is between those two funds, I would want a contractual clauses that say that if B provides A with personal information, then B should take care that they have consent for this export. And then if that's the case, A should be okay with it. Now, what we do see sometimes in one specific example comes to mind, but I won't be too detailed about it, is that the client says we're never going to get that consent, for example, because the information is coming from state-owned companies, right? So basically, our client is a company who collects B2B information, but that B2B information includes contact information of individuals. But his B2B partner is a state-owned enterprise, and state-owned enterprises are very, very sensitive to PI, to personal information compliance, because they've got the whole government breathing in their neck. And so what they're basically saying is a state-owned enterprise is never going to agree that you export personal information that it provides you, because why would they? It just means a risk. Granted, that's a very big problem, because it means that you as a company simply cannot export that information safely, right? And on one hand, you should be getting his consent. The state-owned enterprise says, no, I'm not going to give you consent, or I'm going to ensure that there is consent for export of that information, because I believe you should keep that information in China. How that resolves itself, I think, is very, very challenging, especially in industries where you say, well, but I have to export that information to make it useful. And that would be it could become a very heavy negotiation with a state-owned enterprise. Realistically, there's always going to be situations where you cannot ensure full compliance. And then it's balancing compliance with risk and with the commercial aspects. And I think, that's for companies and individuals who deal with China or have dealt with China for the past years, you will know that there's always this balance between compliance and commercial interest and risk. But these are real problems that do have to be dealt with on a case-by-case basis.
Brilliant. Thank you very much, Martin. So we have about 5 minutes to go. We've had two very similar questions regarding GDPR and PIPL. Could you give us some of the main differences between GDPR and PIPL, and just compare those, please?
I can give you some example. The first one will be the data type, as we just discussed. In GDPR, the scope of sensitive data is quite different from the sensitive data under PIPL. And what's the consequence is that if you are collecting sensitive personal information in China, then you have to collect separate consent from the data subject. And in PIPL, there's no separate consent requirement, and the blanket consent will fit for the legal requirements. So I think this is a sort of a difference between GDPR and PIPL that makes a lot of companies quite different in their actual practice, because, for example, their privacy policy in their website for fulfill the GDPR legal requirement, it's okay to provide a blanket consent tick box. They had a tick box for the client to accept everything. However, if it is collecting data from China, they have to separate the statement. If they collect like the miners information from China, or those ID number from China individual, they have to provide a separate consent. I think that the second difference I'd like to highlight is the personal information, because quite a lot of data protection office in our European companies complains that under GDPR, the data protection, the DPO is not responsible for the company's breach of personal data. However, under PIPL, DPO is personally responsible for the data breach.
And so that obviously means that if there's an issue, then the officers who are appointed to be responsible for it, they have a very personal liability. So you can imagine, in particular for foreign companies and foreign individuals that take those positions, that's a big step upwards. While in the European context, it's the company that's responsible, and the individual should just do its best. In the Chinese context, the individual can be penalized. And as mentioned by both Connie and Alice, you even have prison sentences if there's a intentional fault, or if there's a large-scale breaches.
Brilliant. Thank you, Connie and Martin, for those answers. Just looking at the time, and I think that we will need to begin wrapping up here. There have been a few questions in. We may not have had time for, but as you can see on the screen, we have Connie, Alice's and Martin's email addresses. So we do encourage you to please get in touch with them and get in touch with the firm if there are any questions that you perhaps didn't have time to send in or we didn't get to today. So please do reach out. You will be receiving a recording of today's session as well as part of a follow-up with everybody's contact information if you aren't able to take that down now. Where I'd like to end is just to hand back to our panel. And if you have any takeaways, key takeaways that you'd like our audience to leave today's session with.
I think from my side, the key takeaway is, I mean, there is so much, if you've been following the topic, there's so much being written about it, right? And part of that is because it's still developing. There's still new laws, new regulations coming in. Part of it is because sometimes Chinese laws are written very broadly, and that becomes a very frightening thing. Part of it is also in the global context, right? Countries battling each other through data privacy or extra-jurisdictional laws, etc. My advice is really, don't be too concerned about all that. I mean, it's not so much about the trees and then you don't see the forest. It's about the forest and don't see the trees anymore. It's really about action plans for you and ticking the boxes to make sure that you're doing things right. Occasionally, there are companies that are facing a lot of difficulties because of their business model, because of the challenges as a result of the PIPL and other such laws they are facing in China, which is new, right? They used to be able to do this, now they cannot, and everything changes. And those are the companies that are most impacted and need to do most. And frankly, also, those are the companies that we're spending most of our time on. But most companies are not in that category, and for most companies it is fairly straightforward to deal with compliance and make sure that the boxes are ticked. And for them, I would recommend find your lawyer, find us, find another consultant, make sure that you are as compliant as you need to be, as you want to be. Make sure that you're doing things now if you can, rather than wait from a year's time, and get it over with, rather than being too worried about a topic which seems really, really complicated, but in the end may not be as complicated as all that.
Excellent, brilliant. Well, thank you very much for that, Martin. And looking at the time, I believe we will have to wrap up now. But once again, thank you to our wonderful panel for their insights today. It was a truly fascinating discussion. We really appreciate it and hope that we can have you back again to do another webinar Thank you also to our audience for being with us today. We really appreciate your time. So thank you. I'll bid you all farewell and have a lovely rest of your day. See you soon.
Thank you.
Thank you. Bye.